Good day, panelists. There's no audio. Good afternoon, everyone. We are going to start. We're just waiting for number.
I think we've lost Ntombi. While we wait for her, I think we're just waiting for a couple more people to join us before we start the session today.
My apologies for that. My Wi-Fi went down for a second there. We're going to start now. My name is Ntomfuthi Ntuli. I'm CEO of the South African Wind Energy Association. I will be your moderator for today's webinar. Welcome to the second installment of the Developing Developers webinar series, which is hosted by SAPVIA and SAWEA in partnership with the IPP office, REEF and the Black Energy Professionals Association. As the representatives of the voices of the solar PV and wind industries, we are constantly working towards collaborating with stakeholders across the renewable energy sector to share knowledge and drive effective change in the sector. So developing the South African developers to build the local competence of global standards is very key in accelerating local ownership in renewable energy markets in South Africa. Today's webinar, as you'd remember, we started with just understanding broadly the REEF program. So today's webinar will focus on the legal outlook, focusing on the types of contracts and agreements that developers have to go through in order to build the renewable energy projects. But before we get started, I just want to go through a few housekeeping rules. So to the panelists, I will request you to keep your video off and stay on mute while you're not talking in order to improve the sound quality. And then to the participants throughout the webcast, you'll be able to submit your questions to the panelists in the Q&A function at the bottom of your screen. Please do that as we go along. We will read your questions and pose them to panelists at the end of the session. And also make sure that when you ask your questions, state your name, the organization you represent, and the panelist to whom the question is directed. So we are joined by an esteemed panel of speakers today who have years of experience in dealing with legal aspects of the REEF program. So at this point, I would like to introduce the panelists. First up, we'll have Ms. Thokozile Zambane, who is COO and partner at Bayaka Infrastructure Partners. She will talk to us about the legal structure of the REEF, renewable energy IPPs, companies including developers, sponsors, funders, etc. We will then hear from Mr. Alistair Young. He is an senior associate from Wabatin Attorneys, who will talk about the REEF contracts and agreements, focusing on environmental licensing, authorizations, permits, and permitting requirements. And then lastly, we will hear from Mr. Jason van der Poel. He is a project partner and head of energy sector at Weber Wenzel Attorneys, and he will give us a presentation on the REEF contracts and agreements, focusing on the power purchase agreements and the implementation agreements. And then finally, Mr. Niveshan Govender, who is the COO of the South African PV Industry Association, will facilitate the Q&A session and give us the closing remarks. Ladies and gentlemen, without further ado, I'd like to call upon Ms. Thokozile Zambane. She is an admitted attorney and an entrepreneur. She's committed to playing a meaningful role in the development of the African continent. She spent most of her time as a practicing attorney in the banking and finance team of Norton Rose Fulbright, where she acted as for major corporates, commercial banks, development finance institutions, and state-owned entities. Thokozile has significant experience in structuring, negotiating, deal management, and she has been involved in a number of groundbreaking infrastructure development and PPP projects. And she has worked for more than 10 years in the energy sector. Over to you, Thokozile. We look forward to your presentation. Thokozile, you are on mute.
Sorry about that, guys. Hi, everyone. Thank you very much for the opportunity to come share with you. I'm honored to have been asked to just share some insights in terms of the legal structuring of REEF projects, as well as the contractual framework. We can go to the next slide. So as mentioned, I'm an admitted attorney. My background had been in legal, and I am now the COO of Bayaka Infrastructure Partners. Bayaka Infrastructure Partner is an authorized infrastructure fund manager with a mandate on investing in economic infrastructure. And we have a bias towards energy, with 75% of our investments will be dedicated towards energy projects. And as a fund manager, we are really committed to really playing a meaningful role in the socioeconomic development socioeconomic development on the continent. We can move to the next slide. I thought perhaps before we get into the legals and the nitty-gritty of it, to just take an overview and just take a step back in terms of looking at the South African renewable energies sector and the renewable energy program. So as you can see, a lot of successes in the program, and it then becomes quite evident why, when the South African government has now looked at has put together an economic recovery plan, why energy and infrastructure, a huge emphasis has been placed on them, and specifically the need that's been recognized for the private sector to also participate in the funding of these projects. I think in the recovery plan, the president speaks of saying that we are able to unlock, I think, over 300 billion in funding, in private sector funding, by just focusing on the infrastructure sector. We can really look, we can go to the next set. Yes, so just in terms of unpacking it, I'm also mindful of, just before I get into it, I'm mindful of the fact that participants on this webinar really range from, seasoned industry professionals that have been involved in the energy sector for quite a number of years, and that we also have aspiring developers that would want to participate in the REEF program. So I will then be pitching my presentation really at a basic introductory level to ensure that aspiring developers are capacitated to actually be able to participate, and also hopefully provide the seasoned industry professionals with an opportunity, with a brief refresher, since it's been close to 5 years since we were all playing in the space. So maybe this refresher will be well timed for all of us. As we kick off now, and then before we really unpack the contractual framework, I think it's really important that we understand who the stars of the show are. And I think very often as lawyers, we like to think that we're the MVPs in all these deals. But when we really consider who the MVPs are, and specifically in the REEF program, you're looking at government. Firstly, the South African government for having created an enabling environment for a program like this, and for what is considered globally one of the top 10 renewable energy programs. The second MVP we'd have is the sponsors, which in my mind, sorry, I'm a basketball fan, would be the LeBron James of the MVPs, because the sponsors and the IPPs have actually carried that development risk and have actually moved the project along the development curve, a very challenging and a very long process, very costly process, in order to get the project to a bankable stage. And then thirdly, we have our contractors, EPC and O&M contractors, who are really quite critical in that, you know, they are constructing and operating these power plants, and to go out on the limb and put their money where their mouths are and put their balance sheets on the line as well. And then obviously another critical player that should never be forgotten are the funders, because at the end of the day, somebody needs to pay for all of these power plants. Next slide, please. So when you look at the REEF contractual framework, you know, it's then clear to see that the successful implementation of large-scale projects such as these really hinges on a very complex contractual framework that actually ensures that we're able to effectively construct, operate, and finance these projects. And the legal agreements effectively, as a start, they, you know, as a core, they're protecting the revenue. So they're actually ensuring and binding Eskom to being able to pay a tariff. Secondly, they're creating an enforceable obligation against government and the DOE to provide the government support in the event that Eskom fails to comply with its obligations under the PPA. Thirdly, they also then provide, because what's also key is that Eskom itself as an entity needs to have recourse to the project developers and to the IPPs. So they provide Eskom with that recourse. And in turn, as I mentioned, you know, we've got a key role player being your contractors. The IPP needs to then have sufficient recourse to those contractors in the event of a non-performance of the plant, given that it would have been within the contractor's responsibility to have ensured, firstly, as an EPC contractor, that you are providing a plant at the contracted capacity, and as an O&M contractor, that you ensure that the plant continues to operate at the required capacity. And of course, what's also very important in the structure and what's quite key is important agreements is the land. You know, at the end of the day, with no land, you really cannot have a project. We're not able to build them in the sky. So it's quite important that you then are able to have secured land use rights adequately. And then obviously, like I'd mentioned, the money bags, the people that make all this possible by putting in some debt, the lenders, and we need to ensure that the lenders are then able to actually get that debt repaid. And of course, the IPP and specifically the shareholders, that they are able to actually be able to get the necessary return that they were expecting in the projects. Because at the end of the day, in as much as, you know, we're trying to build this economy, nobody does anything for free, and everybody and equity participants do want a decent return at the end of the day. And basically, so when you look at the overview of the contractual framework, it then becomes very important that in order to effectively participate in the REEF program, it's so important that you have a full understanding of it so that you're actually able to keep an eye out and manage all of the moving pieces, because the moving pieces really tend to impact each other and have a knock-on effect if not adequately managed. And obviously at a first glance, you know, if this is the first time you are coming across and seeing the contractual framework and the structure of it, it can be very daunting. But how do you eat an elephant? One bite at a time. And next slide, please. Okay, so at the center and at the core of any renewable energy program is your project SPV, your project company. It is the entity where all the project rights sit. So from your environmental rights, to any permitting rights that are required, all agreements will be in that project company's name. So at the core of it is this project company, and what And when you're looking at the project company, and the requirement is that this project company's sole purpose, object, and business needs to be the running of this project. Nothing else. This project company can't all of a sudden decide, I'm gonna go, I don't know, I'm gonna go play in property a bit and start getting some tenants. So, and the reason behind that is because, one, you really need to ensure that this project entity, and you want to ensure that it is insolvency remote. You want to know that it's not taking on any obligations outside of the project. And this again will gives lenders the necessary comfort that, okay, if we have ring fenced what it can and can't do, and we have restricted its ability to take certain actions, we can then be sure that this is all that the project company is doing, and we are then able to track all the assets that effectively are owned and managed by this project company. And then what then becomes important, so beyond just looking at, for one, that the project company needs to be ring fenced. So one thing you'll notice that for those who haven't been in the space or familiar with it, you'll notice that a lot of the project companies have the letters RF behind it, and that's really coming from the Companies Act, and it says that in the event, so generally companies have full contractual capacity, they're able to run whatever business that they need to be running, but where restrictions have been placed, or there's been limitations placed on a company's powers, you would then have restricted, and you would then have made the necessary amendments to the MOI, which would have then been filed with CIPC, and that's where then you'd have the letters RF going after the project company. And what also is important to note is, in terms of the REEF structure, there are prescriptions regarding shareholding, because at the end of the day, the program in itself and the success, it's one thing to address the need for an electricity backlog, which we do have, and an infrastructure backlog, but it's another to, but what you have to also have is a balancing act in terms of ensuring that South Africans are actually able to meaningfully participate in these projects. You also need to obviously address historical issues that we have as a country. So you need to ensure that you have the necessary Black entity participation. And of course, what is also important is your local community participation, because at the end of the day, this was my home, I live here, I'm just down the road, you've set up this massive power plant, and I'm watching all of this revenue come in and out, and there's no benefit to me. So there's certain targets, and obviously throughout the rounds, you'd see a change in it. So what you see now, so for example, South African entity participation under bid window 4, so I'm in such a rush to get to bid window 5, was sitting at 40%, that was the requirement. What we're seeing in the risk mitigation round, that has moved up to 49%. I think that's quite encouraging, because it also speaks to the fact that our energy sector has matured, and that we are able, we're really starting to have some really strong local players that are actually able to construct and develop these projects. One thing to note is on local communities, and this was a change that we've seen now in the risk mitigation round. There previously was an obligation on project, in your project structure, that you had a threshold of at least 2.5% for your community, with the target being 5%. What we're seeing in the risk mitigation RFP, and I don't know if then it's perhaps an indication of what we can look forward to in future, is that there's now a threshold of 0 that's been set, which effectively means that if there's a threshold of 0, you do not need this for purposes of bid compliance. And what I think perhaps was driving this change is the fact that to have shareholding in a project company where effectively there's still a lot of debt, it does not provide any kind of meaningful benefit until such a time that that debt has been settled. So in as much as you can say to a local community, oh, you have a share certificate, and you have local communities that are sitting with a share certificate, but at the end of the day, there's no real change in their in their day-to-day lives. So I think that this move really then will drive a lot of developers and IPPs to perhaps consider then, beefing up their other economic development obligations. Because what's really going to make a difference for me, if I'm within a local community that is close to a power plant, or that is within that area, is the fact that I'll have a job. Or if I'm a business owner, the fact that I'll actually be provided with some contracts. And then also what's very key in the project structuring is that so the first major agreement then is your shareholders agreement. And that shareholders agreement really, it's the same kind of principles in terms of shareholders agreements that you would find in any other commercial structure. And that's basically regulating the relationships of the shareholders between themselves and the relationship between the shareholders and the project company. Okay, then what's also important, and the note that's made there in relation to equity contributions, is that these energy projects are funded in a combination of debt and equity. So it's really important that you regulate how that debt, regulate how the equity contributions are made, because at the end of the day, from a lender's perspective, they would have brought in, and dependent on what the gearing would be applied, whether you're looking at 70-30, or in some instances I've seen an 80-20, you want to know, as the lenders will want to know, that if I have to put in my R1, can you also put in yours? So what will also then be required is that in that shareholders agreement, so you can either put it in the shareholders agreement that this is how we're going to deal with equity contributions, or I've seen in some projects where it was a separate equity contribution agreement that dealt with that, and that dealt with the drawdowns, and that spoke to the financing documents as well, and followed the regime that's then within the finance agreements. Next slide, please. Okay, so what then also becomes very important is the EPC and the construction and operations, and that's really where your EPC and O&M contractor play. Again, speaking to the South African landscape, and to ensuring that we have transformation that happens in the sector, there is a requirement again for a BE participant in the EPC contractor, and there you'll also see the shareholders agreement in relation to those entities. But what's really key then obviously is the discussions around your EPC and O&M agreements. And the negotiations around these can be quite lengthy and can be quite contentious. And that's simply because at the end of the day, all construction obligations that you will find in the PPA and in the implementation agreement and in your connection agreements effectively need to be passed through to your EPC contractor. Likewise, all operation agreements in your implementation agreement, your PPA and your connection agreements need to be passed through to your O&M contractor. So in applying this pass-through principle, and you'll find, in the negotiations of these agreements, because the parties that are quite interested in this is obviously your project company, your IPP, your contractors, but your lenders, because at the end of the day, funders want to know what's happening in those agreements, and they really want to, have worked through and made sure that all of the risks that have been identified have been properly identified, and they have been passed to the relevant contractor. So in the process, in arriving or in negotiating these agreements, there will first be, the process of identifying the risks that sit in the PPA, that sit in the implementation agreement, that sit in the connection agreement, and then saying, okay, where does this risk go? And on a clause by clause basis, then you would be transferring that risk. Also, what's very important and a very key clause and a key provision in your EPC and O&M agreement is the fact that the contractors effectively have to bind themselves, or have to say, look, we are committing that we will not put the IPP in a position where it will end up breaching any of the project agreements, whether your implementation agreement and your PPA or any other agreement, well, in this instance, the key project agreements. Because obviously at the end of the day, if the contractor has taken certain acts and now there's a breach of the PPA and the whole system falls down. So at the end of the day, the contractors will then say, look, we're taking the obligation that we will not do anything that will put you in breach, and we will indemnify you accordingly for our actions. And then also what's then worth noting, and what you really pick up in the structure, and it's to the point that I was making earlier, that there's so many moving parts, but all of these moving parts really continually speak to each other and are linked to each other. So what's then important then obviously is the inverse would be true, because if I as the IPP am saying these obligations are the obligations that I'm going to push down to you, then as the EPC or O&M contractor, there's certain kind of claims that I would be making to the IPP under those agreements. And obviously, because that you've got a back-to-back arrangement, as an IPP, you do not want to be exposed and required to perform or to make be exposed to claims from your contractor that you are not yourself able to claim under the implementation agreement or the PPA. So what then effectively, and the solution to this is what's then referred to as equivalent project relief. And what that really means is that your contractors are only allowed to claim, whether it's a payment or time or any other remedy that's then allowable, to the extent that the IPP is able to claim under the relevant project agreement. And I think that's a very important point to make, because again, speaking to how it's all, to how everything is linked up. And naturally then there's an obligation then on the IPP, because at the end of the day, your EPC contractors, in as much as now they have obligations that are stemming from your PPA and your IA, there's then an obligation on the IPP that says, you know, if there's claims that need to be made under those agreements, I can't get there because I'm here behind you. You then have to actually go and pursue those claims and be my conduit. Next slide, please. Thank you. As I'd said, what's very critical to all of this is the land, you know. At the end of the day, if you have not secured your land rights sufficiently enough, you really do run the risk of putting the project at risk. So, and when I say land use rights, you know, it's land use rights in respect of the project site. So where this power plant is going to be, and in that instance, either you would need to, as a developer, have a lease agreement in place, but obviously this is now a long-term lease agreement, bearing in mind the tenor of that PPA. You're not going to get into a 5-year lease, because what's going to happen in 5 years if you don't get a renewal? Like, I'm going to move the power plant, you know? So you have to have that long-term lease in place, and it should also be notarially registered. And that becomes quite important from a lender security perspective. And that's something to also bear in mind, that when you're going through all of these major agreements, it all ties back to the funding that's come into the project and the security that the lenders are going to, that the lenders are then going to take. And part of that security package will then also be rights that the project has under the project agreements. Alternatively to a lease agreement, a simple sale of land, so a title deed. And again, from a lender's perspective, they would want to then get a bond over either the purchased land, or in the case of a notarially registered lease, they're able to also get a bond over that. So, and then also, so in addition to not just the project side, because remember, you need to, as an IPP, be in a position to have sufficient land use rights to be able to operate that plant. So it's not, the operation of your plant is not a function of where it's just sitting and located, but it's also, you know, you're going to, in some instances, may need to traverse third-party rights, and you'll then need to have land use rights there. And what's very important, you know, so in the form of servitudes, you know, a servitude to be able to put up your transmission line, or a servitude in respect of water water pipes that you need to have in place for your plant to operate. But what's then very key in your land use rights and in everything about keeping an eye out on the bigger picture is that you cannot reach financial close until these land use rights have been secured. So, you know, very often there's a delay in getting the developers like delay in getting servitudes in place.
Can I ask you to start wrapping up in the interest of time? I had to do this because it's very interesting what you're presenting on.
Sorry, I thought I had, oh my goodness, I thought I had 25 minutes. Sorry, I'll wrap up. Let me continue.
Okay,
no problem. Sorry, I thought I had more time. No worries. Next slide, please. I'm going to skip this slide because Jason will be dealing with it.
Okay.
Okay, and then the next slide, then we are looking at, again, what I've been speaking about, which is the contractual, the financing contractual framework that you have in place. And it all boils down to the funding of these projects is really done from a project finance perspective. And what that really is that it's long-term finance ranging from 15-year debt to 17-year debt. The payback of this funding is really just only linked to the project revenues. It's limited recourse financing, which means that it's off balance sheet and that the recourse that the lenders would have to project sponsors and shareholders is really limited only to the project sponsors' shares in the project SPV. But I think it's also very important to highlight that in the context of the REEF, there are instances where the shareholders' liability will not be limited. And that's then in the instance where lenders have requested sponsor support in respect of a corrupt act that may have been committed by a shareholder, a breach of an economic development obligation, or a change in control. Then also what's very key here is the risk allocation. That's quite important. And it also ties back to what we were speaking about earlier when we were looking at the EPC and O&M agreement. And the principle there is that lenders want to have the risks that sit with that are placed on the IPP to be pushed to the contract party that is actually best placed to deal with them. And then when you look then further in this regime, and a key aspect of your project financing is the inclusion of direct agreements, because at the end of the day, this is not normal financing where if there's a default, you're saying, okay, I'm taking this, I'm going to go sell. There's too many moving parts. So lenders want the ability to be able to step in the event of a default and prevent a major contract party from actually terminating an agreement, terminating one of the major project agreements, which again will then speak to an all fall down situation for the project. So in terms of direct agreements, very important to consider which project agreements you're going to identify as being a material agreement that the lenders would want to have step-in rights for, and also to agree that upfront with the lenders to try to get an understanding of, okay, what are the key undertakings that you'd want? Because again, because it's a tripartite agreement, there's a lot of toing and froing in it. And yes, of course, there's direct agreements in terms of the implementation agreement or your government agreement. So the implementation agreement, your PPA and your connection agreement, so that if necessary, if there's a default by the seller or the IPP, lenders are able to step into that PPA. And that really is it. My time is done. I can go to just one last slide. I'm not going to speak to it, but I was just a high level overview of the security SPV structure that you will then have to become familiar with as an IPP, where you'll then but I'm not going to go into this because I don't want to rush through it and I'm rushing through a complicated thing, but these slides are available, and should anybody want to discuss this more and get more clarity and understand this specific structure and why we have it in South Africa as opposed to other jurisdictions, I'm more than happy to talk it through. Thank you for the time.
Thank you so much, Thokozile. This has been very interesting, and I'm sure questions are going to come up. I would like to ask participants to please post your questions to Thokozile on the Q&A function, or post on the chat function. I just read Nivetion's comment on the chat. It's asking that when you post a question, please identify yourself, because there's a technical glitch. Everyone appears as Kim Smith. on the list of participants. If you can, please rename yourself, or if you ask a question, please make sure that you identify yourself for our own records. Okay, so we're gonna move on to our next speaker. Our next speaker is Alistair Young. Alistair is an admitted attorney, and he specializes in environmental law with a particular focus in drafting and presenting the environmental findings of due diligence investigations for lenders, investors regarding wind and solar projects associated with the REEF programs, as well as the coal IPP projects and funding of new mine projects. Alistair is going to talk to us about environmental authorizations and licensing requirements related to the REEF projects. Over to you, Alistair.
Thanks, Ntombi, and thanks for the opportunity also to have this chat this afternoon. Thokozile mentioned that there's a lot of moving parts on the contractual side of things, and I think what needs to be borne in mind is that while the contractual aspects of these projects are obviously critical, we can't lose sight of the environmental aspects, which are just as important. And we'll see as we go through the presentation this afternoon, the plethora of authorizations that are required, and you miss out on one of those authorizations and essentially you don't have a project. So that's just a bit of a basic background as to what I'm going to be talking about, but it's just a bit of an introduction into myself and Warburton Attorneys. We're located here in Johannesburg, Rosebank, and as Ntombi indicated, specializing very much in environmental law side of things, renewable energy law.
And you can mention we share an office with SAWEA.
Yes, and sharing offices with SAWEA for quite some time now, and it's a lovely partnership to have. And yeah, we represent quite a few of the existing renewable energy developers. We help them with appeals, and I'm going to discuss the appeal process as we go along. It's probably one of the more nerve-wracking processes that a developer or proposed developer can go through is the appeal process on environmental authorizations. So yes, can we move on to the next slide? And basically what I'm doing is I'm just giving you, well, I've taken extracts out of the risk document that was recently issued by the Department of Mineral Resources and Energy, and basically gone in and highlighted some of the environmental aspects of that. And basically, just to start off with some of the bid requirements, the first one is every bidder will have to submit an environmental authorization as required by NEMA for the project. And if you don't have an existing environmental authorization for your project, then you'll have to show that you've at least commenced with that process, and you've submitted your applications and you've gone as far as to drafting or got your assessment practitioner to draft your various reports, and those reports have been submitted to the department for consideration. We can move on to the next slide, please. And where does this need for an environmental authorization come from? Well, it actually comes from the National Environmental Management Act, Section 24F1A, which specifically says that no person may commence with an activity as listed until such time that a person has an environmental authorization. Now, there's a very specific definition for commence provided for in Section 1 of NEMA. And there's a bit of case law around that definition. But basically, as soon as you've put your spade in the sand, you can essentially be regarded as having commenced with your listed activities that are applicable to that project. Importantly, and it's unlikely to occur within the context of the REEP program, because essentially you have to show the department that you have at least got an environmental authorization in place, or you have applied for your environmental authorizations. But the ramifications of commencing with listed activities without your environmental authorizations are quite significant. Like I said, I don't think you'd even get to be selected as a successful bidder without, confirming that, all the T's have been crossed and all the I's have been dotted with regards to environmental authorizations. But in the event that, you do commence with listed activities without that environmental authorization, you've essentially got to go through a post commencement authorization process. And the first thing you've got to do is pay an administrative fine. Now, there's different ways of calculating that administrative fine, and depending on the impacts that those activities will have on the environment will determine the level of the fine that can be imposed, and it can be up to 5 million rand. And that fine has to be paid before the department will even consider your retrospective application to authorize those activities that were not previously authorized. And the payment of that fine, interestingly, does not guarantee that the department will provide you with a favorable authorization. So you could have gone through all these hoops and jumped through all these, over all these hurdles to get to that point. And then you realize that you've either missed a listed activity on your environmental authorization, and now you've got to apply for it. You've got to pay that fine, and there's no guarantees that you are going to get that environmental authorization after the fact. I think within the context of the renewable energy program, like I said, I think it's highly unlikely that it would ever come to that point. And I think if your project has been selected as a preferred bid, and it turns out that a listed activity was missed, you would have to go through this process. I think it's also, under those circumstances, highly unlikely that the department wouldn't authorize that listed activity after the fact and after the payment of a fine. But we've just got to bear in mind that those are some of the risks of commencing with listed activities without your environmental authorization. Okay, if we can move on to the next slide, please. Okay, so this is just very much a flow chart of the environmental authorization process. And basically, when it comes to renewable energy projects, you are going to have to go the full scoping and EIA route. So it is the longer route. It is a 300 to 350 day process. I'm not going to go through each one of these steps. The be all and end all is the time frame that it takes, and that's the 300 to 350 days, maximum 350 days. And this all depends on if there's any complications during your application. You may have some interested and affected parties who may want some more time to consider the documentation and submit comments on it, and that then pushes out the timeframes to the maximum of 350 days. If you do not, or your environmental consultant who's running this process on your behalf does not complete the process within the maximum of 350 days, basically what that means is your whole application will then fall by the wayside, and you'll have to start afresh. So it's critical to ensure that your timeframes are adhered to, otherwise you will have to start all over again. And 300 to 350 days is obviously quite a lengthy time period within which this process has to follow. There is some potential light at the end of the tunnel, and if we can move on to the next slide. The light at the end of the tunnel is that the department declared in 2018 some various renewable energy development zones. There are 8 of them throughout South Africa, and we can see them all there in that nice map of South Africa. And basically, if we can move on to the next slide, please. What that means is that your activity is going to trigger listed activity 1 and listing notice 2, which is your full scoping and EIA, and that's the development of a project, a renewable energy project with the output of 20 megawatts or more. you know, in the REEP program, I think it's highly unlikely that you're going to have too many projects being submitted under 20 megawatts. But basically, if you are triggering that listed activity there, 20 megawatts or more, and the various other associated listed activities, now just bear in mind, you've got to look at each project from a site-specific perspective to determine which listed activities apply. Obviously, this listed activity 1 and listing notice 2 will always apply, no matter what. But there will be various other listed activities within the various listing notices that will apply. Now, if your entire proposed facility falls within one of those renewable energy development zones, okay, as you can see there, the word entire is underlined. Your whole development footprint of your project has to fall within within a renewable energy development zone. If that is the case, then you can follow the much shorter basic assessment process, and I'll show you the timeframes for the basic assessment process on the next slide. So if we can move on to that next slide. There we go. That's the much shorter process, and as you can see, the main critical aspect there is that the time frame for the department to accept or reject your environmental authorization application is cut down from 107 days to 57 days, and the entire time frame drops down from the 300 to 350 days that you would have had to have undertaken to 147 to 197 days. And this is somewhat of a recognition by the government, is to say, well, you know, we can't have such critical projects, renewable energy projects, being delayed, and potential developers being delayed and being unable to submit bids to any bid process, because they're still going through these lengthy processes, application processes for environmental authorizations. So department recognized this, and this is their way of trying to bring down those timeframes and saying, well, if your project falls within a renewable energy development zone, then we can go this much shorter and quicker application and decision-making route. Next slide. If your project falls outside of one of the renewable energy development zones and you trigger that listing activity 1 and listing notice 2, the 20 megawatts or more, then unfortunately you have to go the full scoping and environmental impact assessment report process, which is back to the 350 days. And once again, I'll reiterate the fact that that word entire was underlined. That means that if part of your project falls within a renewable energy development zone, but another portion falls outside of the renewable energy development zone, then unfortunately you have to go the full scoping and EIA route. It's that small section of your project, the development footprint of your project, that falls outside of the reds, that will then move you outside of that quicker time decision-making process. So I suppose the word of advice that we can take from this is that you look at that map that I showed earlier, you look at the renewable energy development zones, and if you're looking for a project or project site, your starting point is to look within those renewable energy development zones and to try and identify a suitable property within those zones, and try and ensure that your whole project falls within those zones, and then you can rely on the quicker time decision-making process afforded for under these REDS wind and solar PV development zones. Okay, next slide, please. Obviously, it's not just your project development footprint, or the actual wind facility or the photovoltaic facility that forms part of the project, but you've also obviously got your power lines that form part of the project. You have your power lines that come out of the project and hopefully will have to join up with an existing Eskom transmission or distribution line. And part of that process that the government has taken in order to try and speed up the decision-making processes is that they've identified these various electricity strategic corridors. And as you can see, they are set out quite nicely in that map. And if we can move on to the next slide, please. And what effect that has is that if you undertake listed activity 9 in listing notice 2, which is the development of facilities for transmission and distribution of electricity with 275 kilovolts or more, and it's outside of an urban area or industrial complex, then you can go the shorter basic assessment route. Now, the wording that has been used with in this context is the greater part of the proposed facility. So your transmission or distribution line falls within one of those strategic corridors, then you can follow the basic assessment route. There's unfortunately the use of the word greater has not been defined in the legislation or in the government notice that was published that declared these the corridors. So what is actually meant by the greater part is not certain. As far as I know, it hasn't been the subject matter of any judicial consideration, but obviously it means that the majority of the project, your transmission line, would have to fall within that basic within one of those strategic transmission corridors in order for you to follow the shorter BA process. Once again, let me just remind you, activity 9 in listing notice 2 would ordinarily require you to follow the full scoping report process, which is the whole 300 days, 300 to 350 days. And if we can move on to the next slide, which is just a reconfirmation of what the shorter basic assessment process is. And that's 147 to 197 days. So it does represent a very positive saving, time saving in terms of your application process. So once again, looking at a project, you obviously want to try locate the project itself within one of the development zones, renewable energy development zones. And then if your transmission and distribution lines need to hook up obviously with an existing Eskom line, then you would want to try and get your project to, or your transmission lines to fall within one of those corridors, or the greater part of those transmission lines to fall within one of those corridors, so that you can tap into this quicker application process for your environmental authorization. Okay, move on. What we have seen fairly recently, and this came out in about June of this year, was that the department has now issued new proposed wind and photovoltaic development zones. The orange ones are the existing ones, and the highlighted lines are your strategic transmission corridors. The new ones that we have here are up there, reds 9 and 10, which are Emalahleni and Klerksdorp. And basically what these are for solar photovoltaic development zones. And essentially what the thinking is around these is where mines that are no longer active, it can be viewed as a means for a rehabilitation project for those mines. So the two that I've just mentioned there are solely for photovoltaic projects. And then we've got one down in the Western and Eastern Cape, the Beaufort West red zone, which is pretty much, well, it is focusing on new wind energy projects. So once again, the same principles as discussed with regards to the existing reds and corridors would apply within the context of these new proposed new wind and photovoltaic development zones. Okay, moving on. In my introduction, I just mentioned when you're going through this environmental authorization process, you've got to engage, or your assessment practitioner has to engage with interested and affected parties. And during the application process, you've got to present the project to interested and affected parties, and they've got to comment on the project, their concerns associated with the project. You don't really see too many concerns on the photovoltaic side of things, although there are some concerns. We are seeing quite a lot of interest from interested and affected parties, and a lot of comments coming in is on the wind projects. Obviously, a lot of residents see it as a bit of an eyesore on the landscape, and so they submit their comments. If a positive environmental authorization is issued by the department, then those interested and affected parties do have another opportunity, and that is through the appeal process provided for at Section 43 of NEMA. And essentially, any interested and affected party has a right of appeal, and that process is provided for in the appeal regulations. And the net effect of an interested and affected party submitting an appeal is that it suspends your environmental authorization until such time that the appeal process is finalized. So that can have a knock-on effect, and that the REEP documents do require you to set out, if you have been issued with an environmental authorization, whether that environmental authorization is the subject matter of any appeal processes. We have been involved in a number of appeals on wind energy projects, and if we can move on to the next slide, one of the developing trends that we are seeing specifically within the within the wind energy sector are appeals related to the issue of wake effect and turbine turbulence. And I think this is going to come up a whole lot more within the South African context, specifically if we are seeing potential developers looking to develop within those renewable energy development zones. Obviously, there are existing projects within those zones, and what we are going to see is obviously developers looking at those zones because they are obviously known wind resources, and there's existing infrastructure there. You've got these nice time frame benefits with regards to your environmental authorization process. And so what you do is you go and identify suitable land in those zones, and you submit your environmental authorization application, and you've then got a neighboring existing wind farm, and they start submitting comments around the potential for the new or the proposed wind facility to have a wake effect on the existing facility. And for those of you who don't know what a wake effect is that essentially the new project would be placed upwind of the existing facility, so it essentially becomes first in time in terms of getting the available wind resource. And this picture that we are looking at here just shows what happens as the wind moves through a turbine. It causes a turbulent effect on the wind as it passes through the turbines. And essentially what it does is then that wind, the quality and quantity of the wind that is then available for the existing downwind facility is far more reduced. So the quantity of wind is reduced. So that has an impact on the ability of the existing wind farm to produce electricity. It also has an effect on the turbines, in the sense that you can see how turbulent the wind is once it's passed through the turbines. And instead of your turbines turning in a nice concentric circle, it causes the turbines to oscillate, and that has an impact on the wear and tear of the turbines. And so this is now becoming quite an issue within the South African context. And so far we've seen 3 major appeals. So if we can move on to the next slide. 3 major appeals from existing wind energy developers. And the first one that we saw was brought by the Nopoort Wind Energy Facility, and that was in response to the proposed Fezakomoya and Sandkraal wind energy facilities. And as you can see, they were located or proposed to be located in close proximity to Nopoort. And Nopoort said, well, these 2 facilities are going to have a wake effect impact on our facility. And I think it was in the region of around 1% impact on the ability of them to produce electricity, or 1% reduction in the existing energy production. Potentially doesn't sound big in the grand scheme of things, but obviously a lot of financial models were based on what they were able to produce. The new farms come along and it reduces that ability, and it then throws a lot of those financial models out. An appeal was submitted. It was appealed under the guard of the former minister, Minister Mokenyane, and she came back on her appeal decision and said, well, in my opinion, wake effect is not a concern within the realm of an environmental authorization application. Nopoort also asked for the environmental authorization for the 2 facilities to include a contractual clause within it that placed an obligation on the parties to enter into a compensation agreement. So the 2 new facilities would compensate Nopoort for the losses, and the minister said that is also beyond the realms of what an environmental authorization is required to include, and the appeal was dismissed. Just that was quite a couple of years ago now, about 1.5 years ago. Just to give you a quick update on this, Sandkraal and Fezakomoya, the developers of these 2 facilities, have decided to split each one of the facilities up into 2 up into 4 separate developments. They've applied for a splitting of the environmental authorizations. That has now provided Nopoort with a new bite at the cherry, at the appeal cherry, and it's my understanding that they have submitted appeals against the decision to allow the split of the environmental authorizations, and it will be interesting to see where that comes out, because since the original appeal decision, we have now had 2 subsequent appeal decisions. So if we can move on to the next slide. And these 2 appeal decisions were issued under the current Minister for Environment, Department of Environment, Forestry and Fisheries, Minister Creasy. And this was down in the Port Elizabeth area, Bayview being the, Grassridge being the existing facility and Bayview being the proposed new facility. And Bayview would have had a substantially greater impact on the Grassridge facility than what would have occurred on the Nopoort. And the appeal was submitted against the environmental authorization being issued for the proposed Bayview facility. And basically, the attorneys for Grassridge in their appeal made reference to a constitutional law case, which is basically referred to as a fuel retailers case. And in that judgment by the Constitutional Court, and that case really revolved around a new petrol station being constructed in close proximity to an existing petrol station. And the existing petrol station said, the environmental impact, the economic impact of that new facility on our existing petrol station wasn't considered during the environmental authorization application process. And basically what the Constitutional Court came out and said in that matter was that it is imperative during the environmental authorization application process to take consideration of the economic impact of a proposed development on existing developments. And so what the attorneys in the Grassridge matter did was use the decision from the Constitutional Court case and applied it within the context of wind energy facilities and said, look, Minister Creasy, there's this constitutional law case that says economic impacts of a proposed development on existing development have to be considered. There was no wake assessment impact done on by the proposed or the developers of the Bayview wind energy facility. It didn't form part of the environmental authorization application process. You didn't have all the information before you. You couldn't consider the impacts, the economic impacts of the proposed development on Grassridge, and on that basis, you have to set the environmental authorization aside. Minister Creasy agreed. She set the environmental authorization aside and told the developers of Bayview to go back, do their impact, the wake assessment impact assessment, and resubmit the application together with the assessments for consideration again by the department. So quite a different approach to the former minister, very much in line with the Constitutional Court decision. What the Grassridge attorneys also asked for was a similar clause to be included in the environmental authorization, that a condition be included, that an agreement has to be reached between the two parties before any development can take place regarding compensation for any wake impact. Once again, Minister Creasy said that is not the scope of an environmental authorization and refused to uphold or dismiss that ground of appeal.
Alistair, can I ask you to start wrapping up?
Sure, okay. Most recent case is the West Coast 1 development, or the proposed Boulders development. The developers of West Coast 1, this development would have had a more than 2% wake effect impact on West Coast 1. Developers of West Coast 1 submitted an appeal against the environmental authorization for Boulders. The appeal was successful, very much citing the same grounds. Minister Creasy cited the same grounds as what she cited in her decision on the Grassridge matter. And the appeal was upheld. So the developers of the proposed Boulders facility have to go back and do the wake assessment and resubmit the application. So the take home from this is, if you are a proposed developer and you've identified a suitable site that's in close proximity to an existing wind energy facility, you must get your environmental assessment practitioners to do a wake assessment impact. If you don't do that, you are going to be heading into this appeal process that then just drags things out. And I can guarantee you, based on the two decisions that we now have from the minister, the appeal will be successful and you will have to go back and do that wake assessment in any case. So just do it as part of your original environmental authorization application. It is very much a developing topic within the sector, so please take note and do what is required under the circumstances. Okay, moving on, we're just going to have to quickly move through these next slides to wrap up. Water requirements, very much applicable within the context of solar photovoltaic and concentrated solar projects. Obviously, they are located in fairly arid regions of South Africa. They do very much need, well, they do need a lot of water, particularly in the construction phase of the projects, but they do need water also within the operational phase. So that's where the water use license requirements come along. And within that context, moving on to the next slide quickly. I won't go into the nitty-gritty. Let's just get on to the water use requirements. Next slide, please. Yeah, this is the one. So basically, we've got section 21A water uses, which is the taking of water from a water resource, which is very much applicable within the context. This is the picture in the top left-hand corner. Section 21B, storage of water, not potentially applicable within the context of solar projects, but that's probably is triggered. Section 21C, we do see this in the context of wind projects as well. You have to build roads on your sites. Often there aren't roads, and they cross through streams, water courses. You've got to build a culvert and a little bridge over that water course, and that triggers your section 21C and your section 21I water uses. If we can move on to the next slide quickly. There's just a synopsis of your solar energy facilities, the water uses that are triggered by that. Your F, G, and H are typically your disposal of waste, because obviously in your photovoltaic, there's quite a lot of wastewater that's generated through those processes, and you've got to dispose of it. So that's where those water uses come in. Just quickly to move on to the next slide, is your wind energy facilities, your A, B, C, and I water uses. And basically, you can either you will either trigger a general authorization, which is your much quicker water use license process. But you have to fall below certain thresholds, and those are the next slides, the next few slides where I'll set those out, and I'm not going to go through them. But basically, you can apply for a general authorization. It's a very quick, very simple process, and you get issued with a water use, with a general authorization certificate. Move on to the next slide, please. That sets out the process, 30 working days, but you can only commence your water use once you get issued with that registration certificate. Your water use license process is set out on the next couple of slides. Currently 300 days to apply for and get issued. That's what the legislation says. Unfortunately, the Department of Human Settlements, Water and Sanitation is not that reliable. If we can move on to the next slide. Sets out the process for applying for your water use license. 300 days, notoriously bad in sticking to those 300 days. The president in his State of the Nation address at the beginning of the year did call on the department to reduce that process. The department issued a media statement in June this year, and they said they are now moving towards a 90-day decision-making process. Who knows when those regulations will be amended to reflect that 90-day process, but that's the aim of the department. They rarely stick to 300 days, so whether they can actually deal with a 90-day process, it remains to be seen. But in order to stick to that 90-day process, they are going to allow you to do certain application of these steps that you see in these slides outside of the application process. You will be able to tap into your public participation process associated with your environmental authorization application to try and align all the application processes. So that's the water use license process. If we can just quickly move on to waste management license, that comes into play in very much within your concentrated solar facilities. The next slide is a picture of a concentrated solar facility. Down in the bottom left-hand corner there, you see some evaporation dams where all the wastewater is disposed to. generally you need a waste management license for that process. The nice thing about applying for a waste management license is you can align it with your environmental authorization application, and you can do it as one process. So you would definitely then align those two processes. There are a number of other environmental authorization application processes. You've got to get consent from the Minister of Mineral Resources to confirm that the land on which you want to do your development doesn't have any mineral interest. You've got to get your electricity generation license. Generally, most of the land where you are setting up your facility is zoned for agricultural purposes. You have to get confirmation of change in land zonation. Your project needs to get building approval. Most sites have some sort of heritage artifacts on them, buildings, let them be buildings or grave sites, archaeological sites. So you have to get your permits for your heritage sites. Up in the Northern Cape, where a lot of your facilities,
2 more minutes to wrap up, Alistair.
2 more, that's perfect.
Sure.
Where your solar facilities are going to be developed have a lot of protected tree species. I've got 2 slides at the end which give a good example of that. But you've got to get a permit to cut, destroy, or chop any of those protected tree species. We can move on to the next slide. Civil Aviation Authority required. There's various registration processes that you have to go through under the Waste Management Act, which are over and above your waste management license process. You have, specifically within the Northern Cape, you've got to get permission from the square kilometre array that your facility is not going to have an impact on the square kilometre array. If it is, and the square kilometre array has to introduce various mitigation measures, then you will have to pay for those mitigation measures, but you can claim them back through a process, or those costs through a process. And then just quickly wrapping up, there are various other municipal processes to bring home the impacts that can, sorry, if we can move on to the next slide. This concentrated solar facility up in the Northern Cape was located very close to a camelthorn forest. Because of that, and they had to chop down over 1,000 camelthorn trees that were found on the preferred site. This project had to set aside a piece of land, a piece of offset land, biodiversity offset land. So essentially they had to purchase a piece of land and ensure that that property wasn't developed, and the trees on that, so the camelthorn trees on that property were protected for all time. It's been registered as a protected area. And these are just some of the things that you potentially don't consider when you are developing or conceptualizing the project, but they come up during the environmental authorizations processes. So we have, as going back to my initial comment at the start of this period, you consider the commercial aspects of a project at the beginning. Do not underestimate the environmental aspects. They are significant. You skip or miss a hurdle, and it can cause your project to fall flat. That's where I'm going to end off. Thank you for your time, and if there are any questions, we can deal with those at the end.
Thank you so much, Alistair. That was very interesting. And I know this is a topic that actually requires a whole day seminar, because if we talk about legal contracts, there's a lot that needs to be considered. But thank you for making time to impart your knowledge to our audience. We really appreciate it.
It's my pleasure.
Our last speaker for today is Mr. Jason van der Poel. Jason is a partner and head of energy sector group at Weber Wenzel. He has 12 years energy sector experience and overall experience of 18 years. And he's got expertise in a range of areas in project finance. He's advised lenders, sponsors, contractors, and he has worked a lot with PPPs, IPPs, and advising on various legal matters and operations contracts. So over to you, Jason. We look forward to hearing about PPAs and implementation agreements.
Thank you, Ntombi. Thank you to my esteemed speakers, Thokozile and Alistair, that have gone before. It's a hard act to follow. And thank you also to Marlies, who behind the scenes is changing the slides out of the view of the audience. And thank you also to the audience for making this time to listen to all of us. Marlies, could I ask you to move to the next slide, please? So just in terms of agenda, I will talk through a very brief introduction of the project's team at Webber Wentzel that will be focusing on the Renewable Energy IPP Procurement Program and are currently focusing on the Risk Mitigation IPP Procurement Program at the moment. Then we'll talk about the structure and components of those two procurement programs very, very briefly, because these things have been touched on by Thokozile already in a fair amount of detail. An important thing to note there is that we don't know what the RFP precisely is going to look like for the 5th round of the Renewable Energy IPP Procurement Program. And the reason why I've brought in some discussion on the Risk Mitigation IPP Procurement Program is that it may give us some indicators as to what might be in round 5 of REEF. Then we'll focus squarely on the power purchase agreement and the implementation agreement. These are two documents that are non-negotiable and are part of the RFP, and it's among the conditions that you agree to those documents as they stand with their terms. And through the 5 rounds of REEF that we've already had, these documents have proven to be bankable and acceptable commercially. So that at least is a very good sign. Marlies, next slide, please. And the next. So that's the very attractive looking Webber Wentzel team that is focusing on projects. I think that some of you will know that there is a team within Webber Wentzel that has been advising government on the Renewable Energy IPP Procurement Program and also the Risk Mitigation Program. And that team is specifically named on the IPP office website, and there is a very strict ring fencing. So these people that you see on this slide are those that are at liberty to act for the private sector in developing, lending to, sponsoring projects, or acting as contractors or operators. I won't go into any further detail on the team, save to say that we have land specialists, environmental specialists, corporate project finance specialists. So it's a range of skills wrapped into the one team at Webber Wentzel, and I'm very proud of that. Next slide, please. We can skip through the next and the slide after that. These are slides just demonstrating some things about Webber Wentzel and some of the accomplishments that we have. We've advised many parties in the REEF program to date in all of the rounds, different types of projects from CSP to PV to wind to biomass. And we've also advised lenders, contractors, so not just the project sponsors and developers. Next slide, please, Marlies. This is the very broad structure of the REEF program request for proposals. You have part A, which sets out requirements and rules. These are all general rules that set the parameters of what is and is not allowed. So basic ones like don't collude with other bidders in the program. Some of them are quite obvious. And the Department of Mineral Resources and Energy reserves quite a wide discretion to take action to the extent that you breach some of these rules and requirements, including exclusion from the project, disqualification from the program itself. Then very cleverly, this RFP has a section called the qualification criteria, and these set out a number of boxes that must be ticked before your project can move through to the evaluation criteria, which are in part C of the RFP. So the qualification criteria are made up of the legal criteria, which include land and environmental and all the permitting that Alistair was just speaking about. It also includes economic development criteria, so things like your level of black ownership at project company level, your level of black ownership at EPC and O&M contractor level, the amount of job creation that you will induce through this project. There are some financial qualification criteria, and those focus on the track record and the net asset value of the providers of debt and equity finance. And then there are some technical qualification criteria, like making sure that you use the right sort of solar panels or the right sort of inverters or the right sort of wind turbines. And then finally, capacity. Those are the capacity limits of the plant. So wind farms can't be above 140 megawatts, and solar farms can't be above 75 megawatts for solar photovoltaic. And for concentrated solar powers, they may not be larger than 100 megawatts. I wonder if these thresholds will change in REEP round 5. I suppose we'll have to wait and see. And then in part C, the comparative evaluation, or the evaluation criteria, there are only 2 evaluation criteria: economic development and price. And the weighting is 70% on price and 30% on economic development. And economic development is made up of ownership, management, job creation, local content, preferential procurement, enterprise development, and socio-economic development. Marlies, next slide, please. So this is the structure of the RFP for the risk mitigation IPP procurement program. Noting that the renewables program focuses only on renewable energy technologies, the risk mitigation program is an emergency program that focuses on well, they say it's technology agnostic. So as long as you meet certain technical criteria, then any technology ought to be allowed to participate. But when you read the documents more carefully, you realize that this program is focused more squarely on dispatchable power, and it can be supported by renewable energy. So you'll notice that the RFP follows distinctly the same format as the renewable energy IPP procurement program format. So part A, part B being the qualification criteria, and part C being the evaluation criteria. But interesting to note that potentially because of the emergency nature of the power procurement under the risk mitigation program, the weighting for price and economic development is 90% on price and 10% on economic development. So arguably economic development is slightly less important under the risk mitigation IPP procurement program because of the emergency nature of it. Next slide, please. This is a conceptual project overview, and I think probably Thokozile's diagram was a bit better than my diagram, but the reason why I'm flashing this up in particular is to lead into my next topic, which is specifically the power purchase agreements and the implementation agreement. And this shows where those fit in the broader scheme of things in these projects. Everything starts with government. So Minister Gwede Mantashe issuing a ministerial determination under the Electricity Regulation Act saying, I'd like to procure a certain amount of power. So the DMRE is where he sits, and the DMRE is designated in Minister Mantashe's determination as the procuring entity. And he puts out the request for proposals, and these shareholders, the BEE shareholders, local communities, they come together in a consortium to establish a project company that will then hold the project, will enter into a power purchase agreement with Eskom. So Eskom buys the power and pays the project company money for that. And it enters into the implementation agreement with the Department of Mineral Resources and Energy. So that is the agreement where the project company undertakes to make certain economic development outcomes become a reality, like job creation, black ownership, management control, preferential procurement, enterprise development, and the things that we listed before. And the DMRE in turn undertakes that it will provide government support. So to the extent Eskom defaults on a payment that it's meant to make under the power purchase agreement, the Department of Mineral Resources and Energy will step in. It has a charge against the National Revenue Fund. So government backs the payments of Eskom in a very particular way under this implementation agreement. And we'll see some of the other contents of the implementation agreement. You'll see also in this diagram all the things that Thokozile spoke about before. The lenders on the left, the shareholders on the right, the EPC for construction down below, the O&M contractor down below, a block for environmental and regulatory permitting. That's a very important aspect of these projects. You'll also see fuel supply in renewable energy projects like a wind farm and a solar PV facility. There will be no fuel supply because it's the natural resource of the wind and the sun are the things that fuel those projects, and you don't have to pay for them, thankfully. Whereas if you are doing a biomass project, for example, you'd need to get a supply of whatever it is that you're combusting in order to produce that energy. Next slide, please. So with that, we'll jump straight into the power purchase agreement. And this is a very broad, this is a listing of all of the substantive clauses inside the power purchase agreement. So this ought to give you a good sense of the anatomy of the power purchase agreement. The first point to note is that the parties to the power purchase agreement are the seller, so that is the independent power producer, the project company, and the buyer is Eskom Holdings State-Owned Company Limited. There has been quite a bit of talk about an unbundling of Eskom and whether there'll be an independent transmission system and market operator that will be split out of Eskom, first as a subsidiary of Eskom Holdings, and then secondly, split all the way out of Eskom so that it's a totally independent entity. That move will be quite a change in our markets and would serve, in my mind, to liberalize the market and facilitate the private sector participating in these projects. So that, in my mind, would be a very good thing. Then under clause 1, definitions, there are a couple of important concepts that I think it's worth speaking through. The first is achieved capacity. That is how much energy the plant will be able to produce when it is operating at full capacity. So if it's a wind farm, depending on in the ordinary course of a day, a week, a year, you'll be able to determine how many megawatts and how many megawatt hours this project will be able to produce. And that is determined in a moment of testing. And you'll see clause 4 speaks of testing and commissioning, where an independent engineer is brought in to run a series of tests over a period of time and follow a very formal and official process to determine what the achieved capacity of the plant is. Once you've determined what that achieved capacity is, the plant can then get commissioned, and it is commissioned on a date called the commercial operation date. So everything leading up to the commercial operation date is known as the construction phase, the development or construction phase. And then on the commercial operation date, you then enter into a new phase, the operating phase. And that operating phase has a term of 20 years. So for 20 years, you're allowed to run this project and earn money for the energy that you're producing and selling into the national grid to Eskom. And what you are then selling is commercial energy, and you get what is known as the commercial energy payment, which is defined in the power purchase agreement, linking to the tariff that each bidder bid in during the bid submission phase on a competitive basis. And projects will have been chosen on the basis of the competitiveness of that price. And you all know that over the various rounds of REEF, the tariffs have steadily dropped, indicating that the competitive system of evaluating these projects is really working along with the decreasing and increasingly competitive world market for renewable energy and renewable energy inputs. So commercial energy is what you get paid for as an IPP. But if you connect to the grid before the commercial operation date or the scheduled commercial operation date, you get what is known as early operating energy, which is slightly less than the commercial energy payment, but it is a way to make money if you build your plant very quickly and very efficiently. So that is an incentive to finish your project earlier than scheduled. If you are late for the scheduled commercial operation date, there's some penalties which essentially are that for every day that you're late, you lose a day at the end of your PPA term, which is quite punitive, because all of a sudden you can see the term, the time during which you'd be able to earn money off this power purchase agreement shrinking with each day that you're late. So parties are incentivized to organize themselves very well and to achieve this construction within the shortest possible time. There are another series of important concepts in the power purchase agreement which are quite legal in nature. One of them is the compensation event. And compensation events, you'll see in clause 15, consequences of a compensation event. That is when the government party, that is Eskom, is in breach but not a government default, but a compensation event. And that is defined as any breach which essentially doesn't constitute a government default. There are only a couple of government defaults, and those are the most drastic ones, like expropriation, etc. So if there's a compensation event, then you receive compensation. You get paid an amount to make whole for that. Then you'll see in clause 14, consequences of a system event. That is what happens. A system event is what happens when the grid is not available to take the power. You'll know that wind farms and solar farms don't really choose when they dispatch. It happens when the wind blows for wind farms and when the sun is shining for solar projects. And a system event happens when the national grid, the distribution network or the transmission network cannot take the power for whatever reason. And when that happens, you get what is known as a deemed energy payment. So that is an amount that is quantified. I think the financial analysts that I've spoken with say that it amounts to roughly 60% of the commercial energy payment. And it's a payment that gets made to you for the energy that you could probably have sold into the grid had the grid been capable of taking your power. And this is a big issue where the grid is in desperate need of maintenance in certain parts of South Africa, and the grid needs strengthening. You will have seen the press covering reportage around how much money Eskom is planning to spend on strengthening our national grid and expanding it. That's a very big and important issue. Another important item or concept in the power purchase agreement is force majeure. And I think everyone became a closet or not so closet expert in force majeure when the COVID-19 pandemic first hit, and everyone was trying to understand what consequence it would have on contracts. And strangely enough, COVID-19 did not fall under the definition of force majeure under the power purchase agreement. In the renewable energy IPP procurement program, force majeure is very strictly defined as a closed list of very specific items like militants, insurrection, civil unrest. I think it mentions tempest, storm, things like that. Acts of God that cannot be controlled. But it's a closed list which never included a global pandemic. So interestingly enough, you'll see in the risk mitigation IPP procurement program that force majeure definition is now an open definition, which does include the pandemic. And what was interesting about this was as soon as the pandemic hit, people were saying, well, wait a minute, isn't there a force majeure? But realized that the power purchase agreement said that there was no force majeure under these conditions. Yet under certain underlying contracts like EPC contracts and O&M contracts, parties had negotiated that a pandemic would be a force majeure. And then you had a very strange situation where the IPP, the seller or the project company, had to recognize a force majeure of its contractor, but Eskom wasn't recognizing it as having a force majeure. And that underscores the need for what Thokozile referred to earlier on in the presentation about pass-through. You need to pass through those risks. Otherwise, the project company whose sole job it is to do this project and to earn money off it, it then becomes exposed to liabilities that it cannot control. So that is a word on force majeure. And then another important concept under the power purchase agreement is unforeseeable conduct. And that is the term that has essentially been given to what happens when the law changes or a regulatory authority does something which causes prejudice to the project, which was unforeseeable at the outset of the project. And what you get there is some kind of compensation, either money in a lump sum or money over time to compensate you and put you into the position you would have been in had that unforeseeable conduct not happened. Interestingly enough, when there's force majeure, you don't get money. You're excused from having to perform, and the only recourse that you can get for force majeure is an extension of the term of your power purchase agreement. And there's a certain maximum. So you will get extra days added on to your power purchase agreement term for every day that a force majeure has happened. Another important concept that comes up in the power purchase agreement is the lender direct agreement. And if you remember the diagram that I showed you, you saw the lenders on the one side, you saw the project company on the one side, and you saw Eskom and the Department of Mineral Resources and Energy as the parties to the power purchase agreement and the implementation agreement, respectively. And that direct agreement is creates a direct contractual linkage between the lenders, Eskom, the Department of Mineral Resources and Energy, and of course the project company. And what it allows the lenders to do is, if there's a default or a default that is looming where the project company has some issue and cannot pay down the debt, or something is happening in the project that looks like it's going to head into default, then the direct agreement allows the lenders to step into the project to take a measure of control for a certain period called a step-in period, and to try to fix whatever issue is causing this trouble. Because of course the lenders have quite a vested interest, having injected between 70 and 80% of the value of the project in order to have it built. They have a vested interest in seeing that project work and it earning money so that they can not only recover their debt, but so that the sponsors can actually get paid their equity as well. So that is another important concept under the power purchase agreement. Then we've spoken a little bit about transmission and distribution. You connect to your project to one or other of those networks, and that allows for the flow of electricity to where it needs to be, hopefully our homes, and hopefully not load shedding. A couple of other important concepts in the power purchase agreement are government default, and that is referred straight across to the implementation agreement where that is defined. And like I said, those are the most drastic things that government can do, and there are only a few of them, including expropriation. So if the government expropriates your project, then there is recourse and a particular termination amount that you can get paid, which will cover all of the debt and all of the equity. There are a number of seller defaults that are listed in the power purchase agreements, and these are the things to be the most sensitive about, because if one of those things happen, then Eskom is able to terminate the power purchase agreement, and then you will stop being able to earn money from this very expensive plant that you put onto this project site. And the seller defaults that can cause this form of termination are things like insolvency of the seller, the failure to commence construction when you're supposed to, not achieving the commercial operation date by the last commercial operation date, last COD, which is 18 months after the scheduled commercial operation date. It's what happens if the National Energy Regulator of South Africa revokes your license because you've breached one of the license conditions that they've set for you. If the independent power producer abandons the project, if the implementation agreement is terminated for whatever reason, if you change your shareholdings or change your control of your project without the consent of the Department of Mineral Resources and Energy when it's required, that also triggers a seller default, and certain other breaches also trigger seller defaults. Those are the most drastic things that can happen, and those can cause your power purchase agreements to be terminated. So those are the key concepts that I wanted to cover in the power purchase agreement. Marlies, if I could ask you to move to the next slide. Thank you very much. This is just a slide showing the schedules to the power purchase agreement, and they include details of the project and facility, completion milestones and forms of notices, especially the notices around testing and commissioning. It gives detail around scheduled and unscheduled outages, forecasting information, because the plants will tend to generate whenever the wind is blowing or the sun is shining, and you give a weekly forecast and also a daily forecast in advance so that Eskom can plan how much power it will have on any given day, and will determine whether it has a shortage or surplus. There's a list of firms that will act as independent engineer for purposes of testing and commissioning, some details of the deemed energy payment, a list of project documents, the direct agreement, which we spoke about, more detail on outages, and then the form of budget quote effective date confirmation. The budget quote is the letter that you get from Eskom that speaks to exactly how Eskom is going to connect the project to the grid. Next slide, please. Just a brief word on the risk mitigation IPP procurement program power purchase agreement. It has a very similar structure to the REEF power purchase agreement in terms of the clause headings, as you will see, but there's some fundamental differences. One of them is that this power purchase agreement is more focused on dispatchable solutions. In other words, a gas-fired plant or a diesel-fired plant, which can produce energy on demand, almost like the PICA projects or Ankerlek and Barikwa, which are Eskom's power stations that run on diesel at the moment. They are quite expensive, and as a result, the risk mitigation IPP procurement program allows sponsors to add on a renewable energy portion, which is the non-dispatchable facility that might be part of these projects. And so this power purchase agreement has to cater for both of those. But some of the key differences that we've seen in between these two power purchase agreements would include things like carbon tax. Obviously, the emission of carbon is not an issue under a renewable energy power purchase agreement, but is where there's a project with a diesel or a gas-fired element to it. The definition of system events changed slightly, and it split things out into late system connection events. So that is where Eskom connects you late, and system unavailability events. That is when the grid is simply not available to take your power. As I said, force majeure has been expanded to include things like the COVID pandemic, and it's, in my view, a much better definition of force majeure under the risk mitigation program than existed under the REEF program. So perhaps in round 5, we'll see the definition of force majeure from this power purchase agreement coming into the REEF round 5 PPA. I think that's all that we need to say about the risk mitigation PPA. Perhaps one other element would be
Jason, we are at 10 to now. I would like to give you the next 5 minutes to conclude so that we can use the balance of the time to cover the Q&A.
Understood. I'll take 2 minutes.
Thanks, Jason.
Marlies, could you move to the next slide, please? And the next. Let's get to the slide on the implementation agreement. So just to explain what's inside the implementation agreement, there's some really important clauses which I'd like to point out to you. One is government support. We spoke about that before, and that is where the Department of Mineral Resources and Energy steps in and makes payment after a particular process if Eskom has been unable to make a payment to you as an IPP. That is a very important clause, and banks, I think, are very much in need of that assurance from government that Eskom's payments will be backstopped by government because of some of the financial issues that Eskom has faced of late. Then one of the biggest things under the implementation agreement is Schedule 2, economic development obligations. And those are all of the undertakings that the seller makes in relation to economic development. There are provisions around corrupt acts and the consequences of corrupt acts. There is a clause that is quite important about refinancing. And under the renewable energy program to date, you've been able to refinance without consent from government as long as you don't increase the tenor or the quantum of the debt. But now any refinancing will need the Department of Mineral Resources and Energy's consent. And you will also need to follow what is known as the refinancing protocol, which you can find on the IPP website. And that entails a 50-50 gain sharing and a potential reduction in tariff if there are benefits from refinancing. And then finally, change of control and black ownership is restricted. So there's a certain period of time within which you cannot change your control of your project. And if you are going to change shareholdings, including black shareholding, you'll need to seek the consent of the department in order to do so. Possibly the most important clause for lenders of this, well, also for sponsors of the implementation agreement, is what happens when there's a government default and there's a termination payment that gets made that covers your debt and equity. And so where government defaults on the project, they will give you a substantial payment, and which will go a long way to making you whole. If we could move to the next slide. I've got a couple of diagrams about economic development. Let's go to the next slide. And the next, and the next. So this shows if you go back one, please, Marilise, this shows the weighting of some of the elements as between REEP Round 4 and the risk mitigation program. And it shows that equal weighting is attached to job creation, local content, ownership, and management control. If you go to the next slide, you'll see that the risk mitigation program has a new element called skills development, and preferential procurement and enterprise development, as it was under bid window 4, has been consolidated into enterprise and supplier development under the risk mitigation program. And then socio-economic development has a particular weighting, which seemingly was higher in REEP Round 4 than it was in the risk mitigation program. Next slide, please. This shows you that South African entity participation under REEP Round 4 was required to be a minimum of 40%. But in the risk mitigation program, it is required to be a minimum of 49%. So that is an interesting change, and maybe that change will be pulled through into Round 5 of REEP. Job creation, you'll see that under the risk mitigation program, the numbers have increased steadily across all of those different categories of employees. Next slide, please. This speaks to ownership on the left-hand side, and that shows also an increase in the ownership thresholds. So, for example, for the project company, you'll see shareholding by Black people in the seller. The target was 12% under REEP. It is 30% under the risk mitigation program. So it may be that under REEP Round 5, we'll see an increased Black ownership target. So we'll have to wait for the RFP to see whether that happens. And then interestingly, local content under both REEP and risk mitigation programs, the local content threshold is 40% of your spend during the construction phase needs to be on local content. In the risk mitigation program, there have been some questions around whether that is actually achievable in certain types of technologies. So that remains to be seen. And the Department of Trade, Industry and Competition is the department that is monitoring that very carefully. Next slide, please. This speaks to some of the other criteria: skills development, socioeconomic development, preferential procurement, and you'll see that there's an increase from REEP to the risk mitigation program, which likely indicates that we'll get increases in these requirements for REEP Round 5 also. Next slide. That brings us to the end of my presentation. Thank you very much for paying attention and for listening and for the opportunity to present.
Thank you very much, Jason. That was really, really insightful, and we're learning quite a lot today. I've been seeing questions in the Q&A and in the chat function, and I would like to say thank you to all our panelists for making time to participate in this. And before I disappear, I'm going to hand over to my friend and colleague, Niveshan Govinda, who's the CEO of SAPVIA, to facilitate the Q&A session and bring us to the close of the session today. Over to you, Nivesh.
Actually, firstly, thank the participants for the questions, and secondly, thank you to the speakers. I see the speakers today have been very proactive in answering the questions, so they've made my job a little bit easier. They asked a few questions that I want to pose to the panel. The first one may be for Alistair. So there's a question on how the Department of Environmental Affairs monitors commencement of construction under the environmental authorization. Can they take action on a proponent if only very limited early works commence very slowly over an extended period until the full construction program commences? Is there precedence of this kind of thing that happens? So to the authorization not to expire. I think the second part of that question is on the water use license. Is the Department of Water Affairs currently accepting and processing these water use licenses ahead of preferred bidder announcements?
Okay, on the first question, your environmental authorization that you issued with will have an expiry time frame, so it will be issued, let's say, probably these days, I think it's about 3 years. And as we know, a lot of developers conceptualize their projects, they apply for the environmental authorization, and then we sit and wait for a bid window to open. And in the meantime, your environmental, the timeframes on your environmental authorization are running out, and the process that you have to go through is to apply for an extension, and there's no issues with that. Once you've been elected a preferred bidder and your environmental authorization remains valid, then you have to commence, obviously, with construction. And the commencement of one listed activity, so your environmental authorization will authorize all the applicable listed activity, but the commencement of one listed activity, so essentially the placing of the spade in the sand, the ceremonial placing of the spade in the sand, is the commencement of all listed activities. So if your process or your construction process does commence but is delayed for whatever reason, that is not going to have an effect on your environmental authorization. But as Jason mentioned in his discussion, and excuse me if I'm incorrect here, but that obviously does have implications on your other contractual obligations and under the REEF program, which could have a knock-on effect. But in terms of the environmental authorization, that's not a concern. And the water use license, it's a question I get asked time and time again. What is the department doing? The experience out there from developers, from bidders, is that the department is not accepting applications for water use license applications until such time that projects are elected as preferred bidders. But as I mentioned, the department is now recognizing the need for all these processes, application processes, to be aligned. And so what they are saying is that you can take your public participation process from your environmental authorization, and you can apply that to your water use license application process, so long as when you are doing your environmental authorization, you are identifying the water use issues during that process. So if your public participation process doesn't cover your water use license issues or your water use issues, then you can't then tap into that process during your water use license application process. So you've got to make sure that whatever you do during your environmental authorization process is concerned, and you want to tap into that later down the line during your water use license application, make sure you cover the water use issues during that process. And then hopefully by the time we get to some sort of bidding process, the Department of Human Settlements and Water and Sanitation will have got their act into gear. They would have revised the water use license application regulations, and we will be dealing with that 90-day time period. So hopefully the concerns around being unable to submit applications prior to being elected as a preferred bidder will have somewhat fallen away. But that does not remove the concerns around whether the department itself will be able to stick to that 90-day time frame.
Thanks, Alistair. I know a lot of the questions have been answered, so we will try to consolidate them and send them out with the slide pack to everyone so you all have sight of the answers. But one I want to bring back, Thokozile, is the one on communal land or community-owned land. Are there experiences that we've seen where community-owned land has been used for IPP projects? how would one acquire this land, and what kind of lease agreement will be structured with community-owned or communal land?
Hi. So in my experience, I haven't seen that, and I guess the challenge is it's not clear then who actually owns the land. So how would you actually then structure the agreement? Because who are the two contracting parties in that lease agreement? And it becomes very challenging then from a department perspective, but even from a funding perspective, because if I have no certainty of who actually owns that land, it becomes very difficult to then build an entire 1 billion power plant on this land. So so from my experience, I haven't come across any projects on communal land. So I think it's an interesting question. My take is that I think there'd be a challenge given the uncertainty in terms of who's the entity or who actually owns it. But I haven't come across it. I don't know if perhaps Jason or Alistair have come across something like that and how that would be dealt with. But my view would be, I guess the simple answer would be no. I don't think that that's something that just from a risk perspective, I'd really be challenged to use communal land. But I don't know if the other panelists have got opposing views.
Nothing from my side, Thokozile.
I agree with what you just said, Thokozile, 100%. If there's a challenge, if there's ambiguity around who actually owns the land and the quality of those rights for the 20-year PPA term, it's going to be very difficult for DMRE to procure the project and very difficult for the lenders to fund the project.
Good. Thank you for that, guys. One more question to Alistair. So we're talking about the environmental impact assessments. You've noted in your presentation that it takes 300 days to get through this process. For the risk mitigation program, will it be fast-tracked? That's the first question. And secondly, for smaller projects that are on RED's land and outside of RED lands, would this take less time?
The environmental authorization process is extremely strict. It does not, other than the dispensation that's already been provided for by the department in terms of designating the REDs, there's no other fast tracking of timeframes, and there's no real way of getting around those timeframes. So yeah, you know, environmental authorization has become such critical steps in any development. I mean, we can go out even outside of the renewable energy sphere here, and there's just no way of getting around it. And the only way, I think, is and the REDs were declared under this, I think it's called the Strategic Development Act, is if the president himself makes or publishes a notice under the Strategic Development Act to provide some sort of special dispensation. And I don't think that has occurred under this risk mitigation document. So yeah, there's short answer, no way around those timeframes. Sorry, and then the second question.
Sorry, I was asking for smaller projects. So for say a 20 megawatt project.
Yeah, it all boils down to thresholds. You've got under listing notice 1, the thresholds are 10 to 20 megawatts, and then you trigger listing notice 1, listed activity 1 under listing notice 1. But even then, I think that there's a threshold 0 to 10 megawatts. So yeah, there's very little way around it on thresholds, but it's all looking at the specifics of a project, looking at all the listed activities and all the listing notices, and looking at the thresholds provided for in those. And that's what you do hand in hand with your environmental assessment practitioner, and you make that determination to see where you can get around some of the thresholds by changing the scope of the project and trying to fall below the thresholds. But in terms of megawatt output, there's very little way around that.
Alistair, before you go, I see there's a last minute question that's come up on the wake effects. So in your opinion, can DEF require that a wake effect assessment be included in the EIA to assess the impact of projects that are still under development and not yet preferred bidders?
Well, I mean, it's my understanding that SAWEA has been in engagement with the department on the issue of wake effect, because obviously they're representative of the sector. And when I discussed this with a client of mine, he said as far as he's understood, the department has not made any statement to SAWEA to say, well, we absolutely require a wake assessment as part of an environmental authorization. And that's the experience that my clients who have gone through this process and have had their environmental authorizations the subject matter of appeals. At no point in the process did the department turn around and say to them, well, we want you to do a wake assessment. They issued the environmental authorization, and it was only once an appeal appeals have been submitted against the environmental authorization, and the minister was forced to make a decision on those appeals, that they've started essentially setting a precedent. So, what I'm saying as part of this is, rather don't take the risk. Do your wake assessment. You only do your wake assessment, obviously, if you've got a existing neighboring facility. You don't do a wake assessment if there's no existing facility in close proximity, because, well, there's no wake effect to assess. But my word of caution is do it, even if the department hasn't come out with a firm stance on it to say it has to form part of. Well, I mean, in effect, they have put a firm stance on it in the form of two very concise appeals on the issue. But in terms of coming out with a statement to the representative body, they haven't. So, but do it.
Thank you, Alistair.
The summary.
Thank you so much. I think just to wrap it up, Jason, if I can bring you in, I see there's a lot of questions, and you've done a really good analysis or comparison between the REEP round 4 and the risk mitigation. And a lot of questions are coming up on the PPA and the implementation agreement. If you had to take out your glass ball and look into the future of round 5, and I know lawyers are very conservative and hate to do this, but I'm going to put you on the spot anyways. If you had to take out the glass ball and look into round 5, do you see any material changes in those PPAs and implementation agreements? Or can you give an opinion on whether you think the round 4, as that was structured, is a better way of doing it, or the risk mitigation in terms of how that was structured is a better way of doing it?
So my thoughts on that are that the risk mitigation power purchase agreement is a very different animal than the REEP PPA. The risk mitigation PPA deals with an entirely different technology solution. So everything that's linked to that technology solution cannot come across into the REEP PPA. But there are certain improvements that I think have been made to the REEP PPA and the risk mitigation program, like the force majeure clause, like the system events clause. Those things are actual improvements, which actually I think would be well suited to the future REEP round 5 PPA. But it remains to be seen how many of those elements will come across. Likely we'll see things like force majeure, system events, compensation events, unforeseeable conduct, and the introduction of a whole new concept of change in law coming into the REEP round 5 PPA.
Good, thank you for that. Just to reiterate that we have received all of the questions, they have been answered online. We will try to consolidate them and send them out with the slide pack so everyone has access to them if they've missed it. And thank you to the speakers. Thanks, Ntombi.
Thanks, Niveshan. Thanks to the speakers and thanks to the participants. We have come to at the end of our program, and I would like to encourage the participants to please follow our series of webinars still on this topic of developing developers. You can see on the screen the dates for upcoming events. And we have our next one on the 12th of November, which will focus on finance and bankability to financial close. And then on the 10th of December, we'll do the socioeconomic impact. In January, we'll do project development. And February, we do engineering, procurement, and construction. And then we close off with O&M and asset management on the 18th of March. So thank you very much for joining us, and we hope to see you in our next webinar. Great.